Hi everyone, and welcome to our webinar today on some key employment law updates. We're going to be giving you a bit of a whistle-stop tour on what we've learned in 2023 and also what's on the horizon in 2024. So by way of introduction then, my name is Laura Spence and I'm a solicitor in the employment team, and I'm joined by my two colleagues, Suin, who's also a solicitor, and also Beth, who's approaching the end of her training contract in our team. Today we're going to be looking at lessons learnt from the previous year, retained EU law, some new family-related employment rights such as protection from redundancy, neonatal care and the Carers Leave Act. Also, the employer's new duty to eliminate sexual harassment in the workplace, some amendments to the Equality Act, some holiday pay amendments, and also a new right that employees can make a flexible working request from day one, and also predictable working requests. So to kick things off then, I will pass over to Suin.
Thank you, Laura. Without further ado, we'll start by taking a brief overview of some of the main lessons we learned from 2023. I'm sure every one of you here today or listening in today will have seen your organisation changing in some shape or form over the past 12 months. So if you could please have the next slide, thank you. First of all, we saw an increasing amount of employees returning to the office. A steady increase in office utilisation seemed to be the trend for 2023. But the key lessons learned from the office comeback is that it takes time for employees to familiarise themselves with working in person again. Many employees may have gotten into the habit of working from home, which has meant that they have had to reschedule their childcare arrangements, the ways of commuting to the workplace, and their working habits altogether. We may see employees feeling frustrated by the office comeback, but it's important to remind them of the advantages of working in the office rather than at home. Not only does working in an office foster friendship and real connection amongst employees, but it also improves productivity and collaboration. It can also benefit employees by helping them drive their career goals, and it gives employees more exposure to good working practices. Another lesson we've learned through the office comeback is that whilst employers are eager to encourage everyone back to the office, this does not necessarily mean that you need to throw out everything you discovered and that worked well for you during your remote period of work. If a hybrid working model worked well for your business, then why not stick to it? Many companies are still employing a 3-and-2 model, which has them in the office for 3 days and then working from home for 2 days each week, with the view that this can have a major impact on employees' work-life balance. Another occurrence we've seen frequently happening in 2023 was the disruption attributable to strikes across public services. This took its toll on the day-to-day operations of businesses, with many employees unable to commute into work. We also saw teachers on strikes early last year, which had a consequential impact on workforces, as many working parents had to find last-minute childcare or take last-minute annual leave to look after their children. Following a year of frequent strikes, we've learned that it's good practice to talk to your staff. Get an idea of the number of staff that could be affected by industrial action, such as school closures and travel disruption. This is key to help you as employers to plan as best as possible. This will also provide you with more time to prepare your workforce for the anticipated disruptions and think of ways to try and limit the level of disruption. Plan ahead. Once you have an idea of who may be affected by strike action and when, then you can plan ahead. For example, you can show that those affected employees won't have any in-person meetings on the days the disruption is anticipated to take place, making sure that they are set up to work effectively from home on those days. Similarly, you may allow flexibility around working hours to allow staff to work around childcare responsibilities if teachers are striking. Regardless of the approach you take, you should make sure that there's a written record of the plan or approach you've agreed to follow. You should ensure a consistent approach amongst all employees, as the last thing you want is to dispute that one employee is being treated more favourably than the other. Another solution to the problem of industrial action we've learned over recent months and its impact on your organisation is to ask staff to take annual leave. However, if you do follow this approach, we recommend that you make sure to give employees a minimum of 2 days' notice for every day you want to take. The more notice you give, the better. Another change we saw in 2023 was a change to the rules on the rehabilitation of offenders. Now, since the 28th of October, employees have to ask employees or prospective employees as to whether they have a disclosable criminal conviction. That individual is then legally obliged to disclose any convictions that aren't spent. Since October, some criminal convictions have become spent sooner, meaning that individuals are subject to a shorter period in which they must declare criminal convictions to their employer. The purpose behind this change in the rules is to bring many job seekers a greater chance of securing employment and rebuilding themselves, with the aim of making it easier for them to find work and move away from crime. However, for your assurance, we should emphasise that offenders who have committed very serious crimes are excluded from this change. Stricter disclosure rules will also continue to apply for those working with vulnerable people and children through DBS checks. So what does this mean for you as employers? So if you haven't already done so, you should take the time to update your systems and policies to reflect this change on the rehabilitation of offenders. However, you should bear in mind that no conviction needs to be disclosed unless the specific question is asked to the employee or during the recruitment process. We would therefore suggest that you include this question as part of the recruitment process and make sure a policy exists which puts an ongoing duty of disclosure on employees or prospective employees. Moving on, we also saw a new code in 2023 for fire and rehiring of employees. This followed from the PO Fairies in March 2022, which attracted public outrage after they decided to dismiss 800 workers through a video message without carrying out any consultation in the first instance. In response to this, we saw the government publishing a draft code on fire and rehire practices, which is otherwise known as termination and re-engagement. The draft code sets out expected standards when employers need to implement legitimate contractual changes to employees' conditions of employment. It also provides guidance on introducing new employment terms amicably or, if necessary, terminating employees' employment contracts and re-engaging them on new terms. Whilst the code itself is not legally binding on employers, if an employee is found to have breached the code, this could result in an uplift in claimant employees' compensation in an employment tribunal by up to 25%. So the main lessons and takeaway points from the draft code is to reconsider the situation and make sure that all reasonable steps have been explored before proceeding to dismiss. Fire and rehire should always be a last resort, and we suggest that you give careful consideration as to whether this is absolutely necessary. Employees should also be made aware of as much information as possible about the proposed change to the terms and conditions of employment. By having an open and transparent dialogue, this will build trust between you and the employee and allow the employee to fully understand the objectives of the business and the need for proposing the change. Lastly, any consultation as part of fire and rehire should be honest and clear. You should be prepared to consider ideas or changes to your original proposal and continue to ask questions and take the time to understand the employee's point of view to see if we can find the common ground. It's important to bear in mind that consultation needs to be meaningful from a legal perspective. So it must be more than telling employees what you want to do and not being open to ideas. The government haven't set a definite date for bringing the final version of the code into force, we would expect to be sometime in the upcoming months. Then lastly, in 2023, we also saw the retained EU law Revocation and Reform Act 2010 receiving royal assent. But I won't go into further detail in this regard, as I'm going to pass you over to Beth, who will explore the short-term and long-term impact of the retained EU laws.
Thank you very much, Zoe. So if we go on to our first slide on the retained EU law. So retained EU law is a concept created under the European Union Withdrawal Act 2018. This act took a snapshot of EU and EU-derived law as it applied to the UK at the end of the Brexit transition period on 31st of December 2020 and provided for it to continue to apply in domestic law. Now, the retained EU law Revocation and Reform Act 2023 received royal assent on 29th of June 2023, makes provision for major changes to the content and operation of retained EU law and to the rules of priority and interpretation. The Act was introduced to restore parliamentary sovereignty to enable the government to create regulations tailor-made to the UK's needs by ending the special status of retained EU law in the UK. The original intention behind the Act was to reverse the position so that all EU retained law would be revoked on the 1st of January 2024, namely the sunset provision. However, the government originally identified around 2,400 pieces of legislation that would have been affected by that whole-scale sunset provision, but they then discovered an additional 1,000 laws down the back. So there was uncertainty and difficulty in how that was going to apply. So instead of automatically deleting EU-based laws, the new Act keeps everything for the time being unless specifically listed for deletion. Importantly, the list of legislation that was revoked from the 1st of January contained very few of relevance to employment law. The Act instead does the following key things. Gives government ministers new powers to reform EU-based laws. These powers include restating, revoking and replacing. The powers are so wide that you could recreate the concept of EU supremacy with these provisions. It also ended the supremacy of EU law on 31st of December 2023. Under this principle, EU law takes precedence in the event of an incompatibility with UK law. This principle has led courts and tribunals to read words into the Working Time Regulations 1998 to achieve an interpretation compatible with the Working Time Directive. The Act also removed all directly effective EU rights from 31st of December 2023. These are rights from EU treaties that can be invoked by claimants before UK courts. Courts could previously look beyond the wording of UK legislation to enforce such rights. The Act also introduces a new reference process, enabling a lower court, which is bound by EU-based case law, to refer a point of law to the Court of Appeal or Supreme Court, which are not bound, so they can decide if it should be overruled. So if we look now to the short-term impacts of the Act. So lower courts, including the Employment Tribunal, will continue to be bound by EU-based case law, but will have new powers to refer legal points to the higher courts to use their powers to overturn this law. References seem more likely to be called for by employers rather than employees, since EU-based case law arguably tends to be employee-friendly. Practical examples of points that could be re-litigated by the reference procedure include what counts as working time, how to count up the number of redundancies for collective redundancy purposes, what happens to employees when a service is to be transferred to multiple new providers. Also in the short term, the government has new powers to reform EU-based employment laws by writing EU case law decisions into UK legislation to ensure that their effects are preserved from 1st of January 2024. This has already been done to holiday entitlement and pay and non-discrimination. With holiday pay and entitlement, a significant number of European cases focused on workers' rights to holiday, including the principle that employees should receive normal remuneration, including commission and regular overtime. This is now not binding, so the reforms to holiday pay and entitlement clarify the position, which Laura will discuss later on. In terms of non-discrimination, Article 157 of the Treaty on the Function of the EU enshrined the principle that men and women should receive equal pay for equal work and allowed comparison of workers who are not employed by the same or an associated employer, but whose terms and conditions were attributed to a single source. The government has reinstated the effect of Article 157, so the single source test remains by amending the Equality Act. Article 157 is what is being relied on by the equal pay claims made by supermarket workers. They can continue to rely on this, but any similar facts that occur after the 1st of January 2024 will have to rely on the new amendments to the Equality Act. So we are now essentially amending legislation to achieve what we previously achieved by an interpretation of EU law. If we now look at the long-term impacts, anything which happens from 1st of January 2024 will be judged on the basis of the wording of UK law, which will no longer have to give way to EU law. Note that it depends on when the events took place, not when the claim is lodged. Employers should watch out for new case law, and if involved in new tribunal litigation, consider if new points relating to EU-derived law could be argued. Parties might seek to overturn previous rulings that were based on EU case law. This will add to pressure on a justice system already facing a significant backlog. The employment law landscape under a Labour government could also look very different given the general election in 2024. They may make use of new powers to reform EU-based laws. Labour's wide-ranging proposals for reform include major changes to unfair dismissal protection, proposal to ban 0 hours contract, proposals to balance work and home life, including the right to disconnect, flexible working and care responsibilities, proposals to reform employment status, and far-reaching proposals to expand trade union rights. If we now move on to new pieces of family-related employment legislation.
Thank you, Beth. As of April this year, we'll be seeing some new family-friendly employment legislation coming into force. We'll go through each of the changes separately, but to summarise, we'll be seeing greater redundancy protection for those on maternity leave, the right for parents of children to receive neonatal care to take up to 12 weeks of leave, and the right for employees to take 1 week's unpaid leave every year to care for a dependent. So we'll start off by discussing the greater redundancy protection for those on maternity leave. As it currently stands, employees on maternity leave, shared parental leave, or adoption leave already have special protection in a redundancy situation, as they have the right to be offered suitable alternative employment if one is available before being made redundant. However, with this new legislation, the Protection from Redundancy, Pregnancy and Family Leave Act 2023, this will extend the redundancy protections that currently apply to employees on maternity, adoption or shared parental leave to employees who are pregnant or have recently returned to work from such leave. Effectively, it expands protection to a wider group. Therefore, from the 6th of April 2024, this legislation will protect employees who are pregnant or returning from leave to gain priority status for redeployment opportunities in a redundancy situation. The new protection will apply to those who notify you of the pregnancy on or after the 6th of April and for any maternity adoption leave ending on or after the 6th of April. Although this appears pretty straightforward in practice, there may be some hidden implications for you to consider as employers. For employers, the introduction of this new legislation will require careful planning and adherence to legal requirements. Without a doubt, this will have an impact on organisational restructure. So if you're considering or planning to restructure your workforce in 2024, you will need to ensure that you have properly considered the implication of this new protection for returning employees and the issues that may arise as a result. To avoid any risks of a breach of legislation, we encourage all employers to ensure fairness and compliance with the consultation process to avoid potential legal repercussions. This new legislation will mean that there is an increase in the number of employees who could be eligible for priority status in a redundancy situation. Expectant mothers could be provided with a period of protection for nearly 2 years on the basis that they A, inform the employees that they are pregnant at 12 weeks, B, take the full year of maternity leave, and C, are then protected when they first return to work. In light of this, we recommend that you adopt a system for identifying potential suitable vacancies across the business to eliminate any risks of employees claiming that they were not considered for a particular role prior to being made redundant. On the other hand, this new legislation will provide a safety net for employees, as they will have the assurance of knowing that they must be treated fairly and receive adequate notice in redundancy situation. Lastly, it's important that you do take this change seriously, as you could face penalties for getting this wrong. Failure to offer priority employee under this new legislation a suitable alternative role could give rise to a claim for an automatic and fair dismissal, even if the employee in question does not have the 2-year service. In some cases, this could also give rise to a claim for discrimination. Nonetheless, this new legislation aims to strike a balance between safeguarding employee rights for those returning from maternity, adoption, or shared parental leave, whilst fostering a fair and sustainable work environment for all. Moving on to the next new family-friendly legislation, which is governed by the Neonatal Care Leave and Pay Act 2023. At this stage, there's no specific statutory rights for employees to have leave or pay from work if their baby requires neonatal care after birth. Employees are expected to use their existing statutory maternity, paternity, or shared parental leave for this purpose. However, with the introduction of this legislation, employees with a parental or other personal relationship with a baby who is receiving neonatal care will be entitled to time off from work. So neonatal leave will be a day one right. So whether an employee has been with you for 1 week or 10 years, they will still be entitled to the same time off work if their baby is in neonatal care. The length of the neonatal leave itself will be dependent on how long the baby spent in hospital, with parents entitled to up to 12 weeks of neonatal leave, with a minimum being 1 week. It would have to be taken within a minimum of 68 weeks, starting from the date of the child's birth. However, employees will only receive neonatal pay if they have at least 26 weeks service working for you and earn an average of at least £123 a week. Regulations will set out the level of pay in due course, and we'll keep you updated on the developments. It's important to bear in mind that an employee will always need to take neonatal care leave at the end of their other parental leave entitlement. So, for example, an employee cannot reduce their maternity leave to take neonatal leave and then restart their maternity leave. Instead, neonatal leave will be taken at the end of the employee's maternity or paternity leave, or after the employee has returned to work, provided it's taken within 68 weeks of the child's birth. You might find employees extending their overall period of leave, so some employees may exhaust their maternity leave of 39 weeks and then move on to a neonatal care leave for 12 weeks. This would allow an employee to receive almost a whole year of paid statutory leave. We'll pass on to Beth to cover the next family-friendly legislation.
Thank you, Zoe. So the Carers Leave Act 2023 became law on 24th of May 2023, which introduced a statutory entitlement to take a week of unpaid leave per year to provide care. The Carers Leave Regulations 2024 have now been published in draft form, outlining how this entitlement will work in practice. So from the 6th of April 2024, an employee who has a dependent with a long-term care need is eligible to take carers leave. This can be broken down as follows. The employee does not need to meet any minimum service requirements. The leave is a day one right. A dependent includes a spouse, civil partner, child, parent, a person who lives in the same household as the employee, other than by reason of them being their employee, tenant, lodger, or boarder, or generally is a person who reasonably relies on the employee for care. A long-term care need is an illness or injury, either physical or mental, that requires or is likely to require care for more than 3 months, a disability under the Equality Act 2010, or issues related to old age. So how can it be taken? 1 week's unpaid leave can be taken by an employee to provide or arrange care in each rolling 12-month period. The entitlement to 1 week's leave is the maximum any employee could be entitled to, irrespective of how many dependents an employee has. The leave may be taken in either individual days or half days, up to a block of 1 week. There is no requirement to take the leave on consecutive days, therefore employees could take 5 separate days over a 12-month rolling period. The required notice period is either twice as many days as the period of leave required, or 3 days, whichever is the greater. The notice does not need to be in writing, and an employer cannot require evidence in relation to the request before granting the leave. An employer may waive the notice requirement where the other requirements of the regulations have been met. An employer cannot decline a request for carers leave, but can postpone carers leave where the following apply. The employer reasonably considers that the operation of the business would be unduly disrupted if it allowed the leave during the requested period. The employer allows the employee to take a period of carers leave of the same duration within a month of the period initially requested. And the employer gives the employee a written notice within 7 days of the initial request, setting out the reason for the postponement and the agreed dates on which the leave can be taken. Additionally, employers cannot penalise any employee choosing to take advantage of carers leave once it is brought into force. Dismissal of an employee for reasons connected with their taking carers leave will be automatically unfair. Employees are also entitled to return to the same job they were doing immediately before they took carers leave. The Carers Leave Act 2023 represents a significant step forward in recognising the importance of caregiving and providing support to those who need it. With these new protections in place, employees can feel more secure in taking the time they need to care for their loved ones, and employees can maintain a positive workplace culture. Whilst the entitlement does not come into force until the 6th of April 2024, employers should prepare the necessary mechanisms to facilitate carers leave ahead of time to ensure compliance with the law. So Simon will now take you through the practical considerations relating to the new family-related employment legislation.
So in light of this upcoming legislation, our advice to you would be to start preparing your own policies to sit alongside these family leave and pay entitlements. In the weeks leading up to these changes taking effect, you may want to start flagging the forthcoming changes in HR communications to start building awareness amongst your workforce, and most importantly, amongst your managers and line managers. This is because you'll need to be ready to deal with employee requests and any incidents quickly and in line with the latest rules once they are in force. Employees should also understand the logistics of requesting and taking these new family-friendly leave, hence the importance of having an easily accessible policy for them to review. We'd also recommend that you have a record-keeping process to track the number of days of leave employees have taken or you anticipate they will take. Similarly, you'll need to make sure that any software used internally for managing leave requests, such as annual leave, can also be used to request these types of new leaves. It's also good practice to regularly review your data to consider what further support you could provide for employees. For example, allowing additional unpaid time off if staff are using high levels of annual leave to provide care, or if the child is still in neonatal care after 12 weeks. Thirdly, we recommend that you inform and educate managers about these new entitlements and how we will operate in practice. All managers should be aware of the procedures that will be followed from the 6th of April 2024 onwards and the potential sensitivities around this topic. Some employees may not wish their colleagues to be aware that they are taking time off work for caring responsibilities, especially if they haven't disclosed or discussed this previously at work, or they may not want their direct line manager to know of their need to take carers leave. And lastly, we recommend that you offer training to your staff to make sure that everyone is up to date with your new or amended policies and practices in light of this upcoming legislation. As just mentioned, managers will need to understand how to manage new leave requests promptly and in line with the law. Moving on to our next topic today, and that is employers' new duty to eliminate sexual harassment in the workplace. So as it currently stands, the legal framework that governs harassment is set out in Section 26 of the Equality Act 2010. And there are 3 types of harassment. So the first, governed by Section 26, subsection 1, this is unwanted behaviour relating to a protected characteristic. So the characteristics being age, disability, gender reassignment, race, religion or belief, sex or sexual orientation. Secondly, we've got Section 26, subsection 2, which is unwanted behaviour of sexual nature. And then we've got Section 26, subsection 3, which is not on the slide this morning, which is unwanted behaviour of sexual nature in relation to gender reassignment. but the one we'll focus on today is section 26, subsection 2, which is sexual harassment. So when behaviour falls within section 26, 1 or 2, the tribunal must then consider section 26, subsection 1b, as the behaviour will only amount to harassment within the framework of the Equality Act if the conduct has the purpose or effect of violating B's dignity or creating intimidating, hostile, degrading, humiliating or offensive environments for B. The tribunal will have to consider all the circumstances and the objective question of whether it is reasonable for the conduct to have had that effect. The perception of the recipient of the harassment is also very important, and harassment can have been deemed to take place even in the absence of intention, provided that the recipient felt that they were being harassed. If an individual brought a claim for harassment to an employment tribunal, the judge would consider whether a typical person would see the behaviour as harassment. So what is sexual harassment? It's unwanted behaviour of a sexual nature, but this type of harassment does not need to be related to a protected characteristic. The definition of sexual harassment is wide and includes sexual advances, displaying sexual graphic pictures, making remarks about someone's body or appearance, making sexual jokes or comments, catcalls or wolf whistling, making promises in return for sexual favours, or asking intrusive questions about a person's private life, and so on. As it currently stands, the law places the onus on individuals who have experienced sexual harassment to report such incidents to their employers. The onus is not on employees to prevent harassment in the first place. However, in response to the growing momentum and following the #MeToo movement, the UK government has pledged to introduce legislation that will force employers to take active steps to prevent sexual harassment in the workplace. With that, the Worker Protection Amendments of Equality Act 2010 and the Act 2023 has now received royal assent and will come into force in October 2024. This is an important piece of legislation when it comes to sexual harassment. So in short, from October 2024, all employers will be under statutory duty to take reasonable steps to prevent harassment from happening in the workplace. If an employer fails to do so, this could result in an uplift of up to 25% in compensation if a tribunal finds that an employee was subjected to sexual harassment and the employer is found to have breached the duty to eliminate sexual harassment in the workplace. So if an employee or tribunal can point to a step or action that an employer did not take, but it would have been reasonable for it to take, then that employer would be vicariously liable for the actions of its staff. And standalone breaches of this new duty could be enforced by the Equality and Human Rights Commissions. Employers should always seek to avoid investigations from the Commission, as this poses the risk of significant reputational damage and management and resources time taken up. There's no doubt that this new duty for employers to take reasonable steps is onerous, but also a significant milestone in the ongoing battle against workplace sexual harassment. This should be looked at as an opportunity to foster safer working environments. However, it's important to note that employers will not be penalised purely because they have not taken every step to prevent sexual harassment from happening in the workplace. Instead, employees will have to show that they have taken reasonable steps to prevent sexual harassment from occurring. So what does taking reasonable steps mean, and what can you do to prevent sexual harassment from happening in the workplace? So firstly, we recommend that you update your policies. Recommend that policies do more than simply list prohibited behaviours. There needs to be clarity around how you want or expect employees to behave, with an explanation of everyone's individual responsibilities and how employees will be treated if they misbehave. The standards set out in your policy should be communicated to the wider workforce, and they should be understood by everyone. All employees should be satisfied that they know what their behaviour is expected of them and their colleagues, whatever role they play in a given situation. Should also make sure that everyone is up to date with this upcoming change and provide comprehensive training for them. Eliminating sexual harassment should be everyone's responsibility, and it's not all about leaders. Should also make sure that training is tailored to your workplace environment. Those recommend carrying out a risk analysis and treat sexual harassment as you would any other physical or mental health and safety risk. Any factor that increases the opportunity of the scope for sexual harassment to take place in the workplace should be addressed. Following on from your assessment, you should be proactive in your approach and adapt your strategies and practices at work to align with this new legal framework. Consider whether you have processes in place to ensure that you can react swiftly, fairly, and most importantly, consistently to allegations of sexual harassment. Listen to your workforce and about what they need to feel safe at work. If someone has previously raised concerns of sexual harassment, talk to them, obtain their feedback on what you did well and what you could do to improve next time to ensure that the workplace is a safer place for all. We do appreciate that getting genuine data from your employees is not easy, especially if your culture is not particularly used to speaking up on sensitive topics. And lastly, you should ensure that there's support available for those dealing with disclosures of sexual harassment in the workplace. Support should also be available for those managers or appointed individuals leading this work within your organisation. So this could include providing access to counselling through an employee assistance programme or even signposting them for external support to advice lines or charities. So by taking these considerations into account, we hope that you will feel confident enough to navigate conversations with those who have experienced workplace sexual harassment and to prevent sexual harassment from happening in the first instance. By campaigning for a zero tolerance approach to workplace sexual harassment, you'll hopefully provide a safe workplace for all staff. I'll pass you over to Laura now, who will discuss the amendments to the Equality Act.
Thank you, Suin. Lots of interesting things there and room for thought. I'll just say at this point as well, we've not had any questions submitted before today, but if anyone has got any questions, please do feel free to get in touch with one of us at your own leisure. So without further ado then, there has been some key amendments to the Equality Act, and I'm not going to go through all of these now, but from our view, one of the key changes is the definition of disability. In our work, we see this day in, day out when you've got an employee who's underperforming or not behaving, but they've also got a potential disability and the complications that can cause. So really worth drawing this to your attention today. And this stems from what Beth was talking about with the Brexit legislation. This is essentially all stemming from Brexit now. So the Equality Act amendment is designed to retain some vital protections in the workplace, and the definition of disability in particular then. So under the Equality Act 2010, a person has a disability if they have a physical or mental impairment which has a substantial and long-term adverse effect on their ability to carry out normal day-to-day activities. An activity will usually be a normal day-to-day activity if it is something people do on a regular basis, such as shopping, reading, writing, having a conversation, using the phone, watching TV, and getting washed and dressed, preparing and eating food, and carrying out household tasks such as walking, using transport, travel, and/or taking part in social activities. So the definition of disability will now include a person's ability to participate fully and effectively in working life on an equal basis with other workers. So essentially, it's going to be easier for people to establish a disability. Moving on now then to holiday pay. Something which gives us employment lawyers a bit of a headache, we're not afraid to admit. And there are some changes coming again with this. They actually came into force very recently, beginning of January this year. So please do bear with us whilst we're getting our heads around these changes. But at the moment, this is what we know. So firstly, there is going to be a new holiday entitlement system, providing that holiday will be accrued based on 12.7% of the hours worked by the individual in the previous pay period. This converts the UK statutory holiday entitlement for full-time workers of 5.6 weeks. So that's where that 12.7% figure comes from. And this may sound familiar to you. It may seem like there's been no change at all. But for the past year or so, we've been telling all of our clients that this 12.7% method is no longer correct. And instead, you have to refer to the case of Harper Trust v Brazel, which essentially says you calculate holiday pay by figuring out the average pay over the preceding 52 weeks, or if the employee hasn't worked for 52 weeks, then however long they've worked. And this only applies to your atypical worker, so your casual workers and your part-year workers. And the legislation has usefully defined what irregular hour workers means, so we know exactly what this change applies to. So a regular hour worker is someone whose hours in each pay period are wholly or mostly variable under the terms of their contract. And a part-year worker is someone who is only required to work part of the year under their contract and who has periods within that year of at least a week where they're not required to work at all. So, for example, a seasonal temp may fall within that definition. And importantly, where an individual has periods of absence through the year, such as maternity leave, therefore the 12.7% method will not be workable. Their holiday accrual will instead need to be calculated over the 52-week reference period. So some interesting room for thought there, but this does generally only apply to your atypical worker. Okay, the next change is rolling up of holiday. So this may come as happy news for you because it is supposedly more flexible and easier for employers to work sometimes. So rolled up holiday is now permissible. It was unlawful for a long time for irregular and part-year workers. And this involves including an additional amount for holiday pay with regular wages throughout employment rather than paying it when the holiday is taken. And this applies for holiday years from 1st of April this year onwards. And again, it only applies to the atypical worker. If this approach is adopted, then it must be calculated using that 12.7% method of the worker's regular earnings during that pay period. And for this purpose, a pay period is the period from which you get paid. So if you get paid monthly, then that'll be your pay period. And really importantly, the holiday pay needs to be itemised on the payslip really carefully, distinguishing it from wages, and records should be kept to demonstrate compliance with this. Again, a 52-week averaging system will apply for workers on sick leave or statutory leave, such as maternity leave. So you do not have to implement this. It is merely an option. It's just to let you know that it is now no longer unlawful. So you can implement this if it is more convenient for you to do so. The next change then is some rules regarding carryover of annual leave. So leave can now be carried over in the following circumstances and in the following way. So the full 5.6 weeks can be carried over if leave cannot be taken due to family-related leave, such as maternity, adoption, shared parental leave, and paternity leave. 4 weeks can be carried over where it can't be taken due to sickness, but importantly, that can only go forward to a maximum of 18 months, so it can't be going forward any longer than that. And also, 4 weeks can be carried over if the employer has failed to recognise the worker's right to take leave, or failed to give a reasonable opportunity to take it, or failed to inform the worker they will lose their leave if it is not used by the end of the leave year. So we highly recommend updating your policies, ensure there is open communication with your staff, and keeping records so that you can ensure that you're not having to have up to 4 weeks leave carried over. So the next provision then is in relation to COVID, and I'm not sure if anyone listening here will have staff that are affected by this, but during the pandemic, legislation was introduced which essentially said that if you were not able to take annual leave, it could be carried over for a period of 2 years if that was attributable to COVID. So now some time has passed, we've come out of the pandemic, so now this is being revoked, and all carryover accrued leave from these circumstances must be used by the 31st of March this year, or it will be lost. So really important to be checking your records and seeing who has still got leave from COVID, because they need to be told that it needs to be used by March or it will be lost. Really usefully, we've got some guidance on what normal pay will include, because when you're calculating holiday pay, you need to know what normal pay there is. And we've got guidance that this will include regular overtime. It will include commission payments that are linked to the performance of tasks contractually obliged to carry out, and payments relating to professional or personal status, such as those based on length of service, seniority, or professional qualifications. And also some other regular payments, whether they be contractual or not, that have been a consistent part of the worker's earnings in the preceding 52 weeks. So really important here, especially for those that have got some high commission payments for their staff, just to bear in mind that this may incur some more costs for you, and to be aware of that. And this only applies to irregular and part-year workers, but you can choose to use this method for all staff if you wish. Okay, moving on then, and I believe this is the last thing that we're talking about today, is the Employment Relations Flexible Working Act 2023. So essentially, from 6th of April 2024, it will be a day one right to make a flexible working request. And it's not completely surprising that following the aftermath of COVID, that hybrid working and working from home and part-time working is becoming the norm. And this has been recognised with legislation. So we're now going to have this day one right to make a flexible work request. That's not to say it will be accepted, but it's just to say that you can make a request from day one. So this may be familiar grounds to some of you, because this right has been around for a while, but there are some changes to the structure of how this is going to look. So from this year, employees can make 2 requests in a 12-month period, whereas it used to be 1. The request does not need to include a business case to justify it. The employer has only 1 month to respond, and consultation is required if the employer is considering rejecting that request. And usefully, ACAS are in the process of releasing a statutory code to assist with that, and that's likely to provide some guidance on what reasonable consultation may include. We're not going to go through all of that today because it is quite a hefty code, but please do take the time to familiarise yourself with that, as it is in draft form, and I'm sure we'll be releasing updates when the final code is out as well as part of our newsletter. So some actions that we would suggest at this point then: update your policies. We'd suggest getting ahead of the game and making sure that things are aligning with this, but also consider including flexible options such as hybrid working policies to minimise requests. So if your business is comfortable with hybrid working, then perhaps pop that in your policy so that employees can refer to that, rather than putting in a formal request and you having to deal with that. As I've said, get familiar with the ACAS code, because that hopefully will provide lots of guidance. And also consider including flexible options in the job advert. So this hopefully will filter out any problems from the start, because if you don't foresee flexible options being available in a role, in particular working from home, for example, then it may be useful to pop that in the job advert to prevent that employee from applying. And to ensure some fairness, we recommend, if you are going to implement flexibility, then ensuring there is some flexibility across the board for all roles. That's not to say you have to offer the same option for all staff, because it may not be feasible for one employee to work in a way that another employee can't. But as long as there are options for everyone, then that should be sufficient. So similarly then, the Workers' Predictable Terms and Condition Act. So really similar to making flexible work requests. This is expected to come into effect in autumn this year, and it essentially creates a right for more predictable working conditions. And it applies to workers with at least 26 weeks service. And it applies to workers or employees where there's a lack of predictability in relation to their work pattern. So, for example, shift workers. The application must be in writing. It must state that it's a statutory predictable working application and specify the change applied for and the date on which it is proposed to take effect. And similarly to flexible work requests, the employer will have 1 month to respond. Again, workers can make 2 requests in a 12-month period. So what does predictable mean then? Well, this can include some certainty over the number of hours worked, the days worked, and the time on those days worked. So if any of your staff's working pattern currently isn't consistent and doesn't have certainty over these factors, then they may well be eligible to make a predictable work request. So who will this affect? It's quite a broad criteria, but it is going to capture quite a lot of people, likely to significantly impact casual staff, 0-hour workers, and those that hours vary, such as shift workers. And we have been specifically informed that all contracts of less than 12 months will be considered unpredictable for these purposes. So it may be worth bringing staff on contracts of 12 months or more to avoid lots of these requests. So how to respond then? As I said already, the response must be provided within 1 month, and it must be dealt with in a reasonable manner. And again, usefully, ACAS are expected to provide some guidance on what reasonable means, and it is probably going to include things such as meetings, appeals, and accepting when possible. You can only reject the request if one of the following grounds applies in relation to cost, detrimental impact on customer demand, a detrimental impact on recruitment of staff, other business needs, insufficiency of work during periods that the work is requested for, planned structural changes, and also such other grounds as the Secretary of State may specify. So the idea is here that it should really be accepted where possible, but if one of these conditions does apply, you may be able to justify rejecting that. Okay, that's the end of everything we are going to discuss today. Thank you so much, everyone, for taking the time to listen. As I've said, if you've got any questions, please do feel free to get in touch with anyone from the employment team, and we'll be happy to come back to you. Thanks a lot.